Good morning. Happy hump day. I apologize for making 3 videos yesterday. Information just kept coming in, and to recap yesterday, in case you didn't bother to watch all 3 videos, Frauder Troll lost his motion to dismiss for form nonconvenience, and also lost his motion to force DMA to pay a bond. In addition, the parties agreed to settle. They filed a notice of essentially a notice that they have achieved a resolution in all but the final details, and so they're just going to hammer out the final details, and they asked the court to stay everything else until the parties manage to finalize their settlement. So that is a massive indication that the parties are settled. And the court yesterday issued an order essentially staying everything per the parties' requests and requiring the parties to have entered their dismissal by, I think, June 4th or some. The date doesn't matter. The important thing is that the courts, just like me, recognize what they've done as you have probably settled, and I'm just putting deadlines in to make sure that the appropriate steps are taken. So, and then the other thing was Rusty Moore, who no one probably cares about, did plead guilty, and he got 6 months probation, and at the end of his probation, his conviction will be dismissed. So that was from yesterday. Today, I want to talk about one of my leading Dunning-Krugers, who's all over my comment sections, thinking that he knows things that he doesn't know, made a statement, and I didn't want to correct him in the comments on it because I think it's a common thing for a lot of people. And so I want to address it to a lot of people because I know most people don't read his comments, even though he's in there giving his opinion. Like, every comment in my comment section, just about, I mean, it seems like it, he will respond to as if he's me. Like, he'll respond to all these things, like people want to know his opinions, people want to know his understandings. He'll come behind me and try to correct me if I don't like fully respond to a comment. If I just address the issue that I see in the comment, he'll come behind me and try to show how he's so smart and he knows more than everybody else. But one of the things that he said was that Randy, DMA's lawyer, believed that he should be automatically entitled to attorney's fees based on the motion that he filed. Now, for those of you who aren't fully involved in the lore in Frauder Troll versus DMA, or DMA versus Frauder Troll, I should say, Frauder Troll filed a SLAPP motion, or a SLAPP claim, strategic lawsuit against public participation. DMA filed a motion to strike, an anti-SLAPP motion to strike that particular cause of action, that claim. And then Frauder Troll came behind immediately the same day and filed essentially a motion to dismiss his own claim. And then DMA followed up, Randy's attorney followed up and said, I don't really oppose them dismissing the claim because that's giving me what I asked for in the motion to strike, but their order is also asking, for no attorney's fees to be awarded. And I'm opposing that because I essentially won my motion to strike, and if you win your motion to strike, the presumption is that you get attorney's fees, and so I want to still be able to get the attorney's fees that I request in the motion to strike. And my Dunning-Kruger said that Randy believed that he was automatically entitled to attorney's fees. Now, First of all, Randy didn't say that he was automatically entitled to attorney's fees. He wanted the attorney's fees portion of his motion to strike to survive, and he argued for that. Now, what an attorney argues for is not necessarily what an attorney believes he will get. Again, I bring you back to Fraud or Troll's attorney, I'm going to call him Lou, filed a motion to dismiss for form nonconvenience. And in previous videos, you've heard me say that there's a lot of reasons why he might have filed that, not all of which would imply or suggest or require him to believe that he would win on the merits of that motion. There are strategic reasons, there are tactical reasons why he might have filed that motion that don't require him to think that he actually has a chance of success. I personally seriously doubt he thought he had a chance to succeed, but I don't know. I merely offered that, there might be other reasons why he would do this other than believing that he would win. And there are reasons why Randy would have opposed the portion of the order that Fraud or Troll filed that suggested that no attorney's fees be awarded. And the obvious one is, if you don't ask for it, you don't get it. I already have my motion filed. I have to wait for this motion to get resolved, which in federal courts can take months. In state courts, it can take months too. But, if I don't ask for it, I don't get it. I've already filed the motion. See if the court will give it to me. That doesn't mean he believes he would win. And it also, nothing in there suggests or implies that he's automatically entitled to them. Because again, Randy's not dumb. Randy knows that he's going to have to prove by Lodestar the amount of attorney's fees he would be entitled to. And he had not done that yet because obviously he didn't know how long it would be. So even after the court says you're entitled to attorney's fees, he still has to prove that he's entitled, what attorney's fees he's entitled to. And again, Randy's not dumb. He's a competent attorney. He knows he would have to prove that. But my point is, there are very few situations where you can say what an attorney believes. Even in the case where an attorney takes a case on contingency, I always say, 99.999% sure that he took this believing that he would be able to recover sufficient damages to make it worth his time to do the case. Now, there are exceptions to that. You don't know that that's what he's thinking. He might be doing it as a favor to a friend. He might be doing it as a tax write-off. He might be doing it because if he wins, he can gain more clients. Like Randy's purpose in this Fraud or Troll case, he might not have thought that he's going to recover much in the way of damages. I don't know. He might be doing this just for essentially the free advertising, having idiots like me sitting in a car telling people about this case and having to say over and over again how Randy's a competent attorney. I mean, I don't really particularly like to say that, but I mean, the facts bear it out. I don't have a choice but to say it if I'm honest. And I have a duty, an obligation to be honest. So I have to say he's competent. So he's getting free advertising out of this. And I'm sure a bunch of other auditors are seeing Randy's success and retaining him. And, he might be making good money off of this. He's already settled a couple cases. What was it? Executive Lens versus, there's two of them. Rapkin. Was it Rapkin? I don't know. He settled two of them at least. He got a default judgment against Irish Demon, or he got a default against Irish Demon. I don't know if he got the judgment yet. I'm assuming there's going to be collection issues there. I mean, good luck to him. But he might have other motives. He might not have believed that he was going to succeed on this. So anybody who tells you what another person believes is probably full of shit, is probably either lying to you or too stupid to understand that he can't read someone else's mind. And this guy's over and over in my comment section proving how stupid he is. Arguing with lawyers who understand the process, who understand the language, who understand the law. There's a lawyer who posts in my comment section, The Firm, I think his handle is The Firm. I don't know who he is, but from what I have seen him say, that guy's a lawyer. I mean, he's a lawyer. He talks like a lawyer. He analyzes cases like a lawyer. I have no reason to suspect he's not a lawyer. So I'm going to say he's a lawyer. I could pretty much pick him out. You know, I have a lot of people who tell me they're lawyers, and I'm like, bro, you're not a lawyer. Like, I have no reason to believe you're a lawyer because you're fucking retarded, and you don't understand the language that's being used. You don't understand the implications of things. You don't understand the process. But this guy's a lawyer. And my Dunning-Kruger was like arguing with him because non-lawyers, hashtag not all, but the general rule is non-lawyers don't understand legalese. Like the sovereign citizens like to say, you know, you're talking legalese. Yeah, it is. There are terms of art in the law that lawyers understand that laypersons don't really understand. I mean, they might have a dictionary definition of it, but it's not internalized. They don't understand like the ramifications and the concepts of it. And so, like, as a lawyer, when I see a judge saying, you know, your motion to strike is dismissed as moot, but you can still file a motion for attorney's fees, I read that because of my experience, because of my training, because of being a first-year family law attorney for as long as I've been a first-year family law attorney. I read that as the court saying, you're probably going to get attorney's fees. If you just ask for it in the right way, you're probably going to get attorney's fees. So ask for it in the right way. Non-lay persons, like Fraud or Troll, like Dunning-Kruger, saw that as, oh, Randy's got to prove up all this stuff. Well, I mean, kind of, but no. He's got to file the motion. He's got to ask for it. He's got to say that the onus is on Fraud or Troll because the presumption is that Fraud or Troll did not gain a litigation advantage. And then he has to essentially prove the attorney's fees that he believes he's owed through the Lodestar. And I keep saying Lodestar, and most of you might not be aware of this, but Lodestar is essentially where you have to prove what attorneys of your skill and experience practicing law in your area of law, in the area of law where you're practicing it, this is what they tend to make. So Randy's been an attorney for, I don't know, let's say 20 years. I don't know how long he's been an attorney. You say, you know, attorneys practicing copyright law for 20 years in the Northern District of California, on average, make this much an hour. And I'm an attorney with 20 years of experience practicing law, copyright law in this area of California, Northern District of California. And so I'm entitled to that. They have to prove it. That's the Lodestar. You don't just get to say, you know, my standard billing rate is you know, $700 an hour, and I spent 20 hours on this motion and blah blah blah. You have to essentially prove it. That's what the Lodestar is. But I can just say Lodestar to an attorney, presumptively, if they've practiced civil law, and they'd understand what I'm talking about. They'd understand, oh, he means the Lodestar way of proving what you should make, what you should be getting. Because you could have a billing arrangement with your client for like $1,200 an hour, but if an attorney of your experience and practicing law in that particular field in your particular area only makes $400 an hour, the court's not going to give you the $1,200. The court's going to be like, $400 an hour is what you're worth, bro. You know? I mean, you may be an excellent attorney and you may be able to convince clients you're worth $1,200 an hour, but no, you get $400 an hour. So if you aren't steeped in it, like, you make all sorts of mistakes along the way, all sorts of misunderstandings along the way. You can't interpret what the court's actually saying. If you don't understand the cases the judge is referencing, you don't understand what's going on. If you don't read those cases and understand them, you know, there's not only do you have to read, but you have to be able to interpret the law like a lawyer interprets the law, because the judge is a lawyer. And the judge writes like a lawyer and thinks like a lawyer. And the opinions are going to be a lawyer's opinions. A lawyer wearing a black robe. And so you kind of have to understand. You kind of have to be a lawyer to really understand. And I'm not trying to be like classist or anything like that. I'm not trying to think that my shit doesn't stink. As a lawyer, I mean, I'm a first-year family law attorney. I'm about the bottom of the tier. I mean, BK attorneys are the only things that I think are substantially worse than family law attorneys. But at the end of the day, having the law school experience, having practiced law for at least a year, you start understanding things in a way a layperson can't. So that's my rant. Thanks for watching. Have a great day.